All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. We are here for a bill hearing. The chairman of the House Judiciary Committee is here to present House Bill 824. Mr. Chairman, welcome.
Going back to the bill as it was introduced, I have my counsel or as it was sent over from.
If you'd like to come up to the table, that's excellent.
I have my counsels here as well. Senate Bill 824 was drafted with the eye towards figuring out how to go forward effectively in a post-Bruin world. I'll keep my remarks very brief, but what the bill as it was sent to the Senate would do is it would do a number of things. First, it changes and adds restrictions on people who are able to possess or get wear carry permits if they had been convicted of a crime punishable by imprisonment for more than a year, if they violated a driving while impaired or driving under the influences of drugs and or alcohol, or for violating a protective order. The bill says that if while they are on supervised probation after a conviction for any of those offenses, they would be a prohibited person for possessing or getting a wear carry permit. It also, as it was introduced and then as it was sent out of the House, created a fix for the storage situation where it said that if someone had violated the existing storage law, that for a first-time offense, they would be banned from a regulated firearm for 5 years. For a second offense, for life. If the first time the gun was used in an event that involved death or serious bodily injury, the person would then be forever a prohibited person in that case. The legislation increased the fee for a wear and carry permit from $75 to $150 and $50 to $100 for renewal. We have information, and of course, I've just run across the street, but I know that we have information from the state police that deals with the money side of this, and I actually have it right here. In fiscal year 19, the fees brought in $2.5 million, and the cost of the licensing division was $10.6 million. In fiscal year 20, the money brought in fees was $3.5 million. Licensing division was 11.1. In 21, it was $6.5 million, and the licensing division cost $16 million. In 22, it was $4.3 million, and the licensing division cost $15.7 million. And so far in fiscal 20, well, as of January of this calendar year, it had brought in $9.6 million, and the licensing division so far this year had cost $20.8 million. According to the fiscal note, as it left third reader and went across to here, the difference between what was coming in with the increased fees and the increased costs to the licensing division was about $6 million. And being sensitive to the constitutional standards that this cannot be a money raiser for the government, it would still raise less money than what it costs to actually run the program. It added the bill as introduced also added to the wear carry requirements the rules that were already existing in the handgun qualification requirements with regard to involuntary admission. It also added involuntary admission to a mental health facility under 10-101 of the Health General article. It indicates that you could not get a wear and carry permit if you were a person who was a respondent in a protective order hearing or in a red flag or ERPO hearing. 824, as it crossed the street, changed the requirements for the class that you have to take in the wear and carry program. I understand that the Senate and Senate Bill 1 changed those again. And I would say for the record that I think that those changes were good ones. And so I would just proffer that. Having said that, I believe that those are moving in different places, at least at the moment. But having said that, that was in the bill as it came across. And then there's a information and data requirements that were in the bill as it was introduced, that requires the state police to provide information about why a permit was revoked or denied. And it requires the state police to keep information about where the counties where people are requesting the permits, how many were denied, and the backgrounds of and I just forgot I think it was the age, gender, and race of the people who were having their applications either revoked or denied. That is the somewhat short version. So I'm happy to take any questions that you have.
Excellent. Thank you very much, Mr. Chairman. So we've I know the chairman's got to get back to his committee and the floor, so we'll entertain a few questions.
And just since you're all sitting here, just so you're aware, we already have contacted your offices because I know you're going to be here. We're happy to take staff members. We know there are 31 witnesses who want to come and talk about the bills that we're hearing this afternoon. Happy to take your staff members so that we can move those along.
Excellent. Thank you very much, Mr. Chairman. All right, we're going to start off with Senator West and then Senator Folden.
Sure.
Thank you, Mr. Chairman, and thanks for offering to take our staff members. I've asked
Sure.
our intern to come over and present my divorce bill, so you'll be happy to meet him. So my only question is, have you run this particular bill by the Attorney General or any other legal counsel to find out whether or not it complies with the Bruin decision?
I haven't specifically put this bill in front of the Attorney General, but I've read Bruin.
Yeah,
And
so have I.
I've read Bruin extensively.
Congratulations, it's long.
It's long, and it's not only, is there there's the majority opinion, but there's the opinion from Justice Kavanaugh and the Chief Justice that also speak to the things that we can and can't do, and the non-exhaustive list that he talks about in the opinion. And I feel that what we have here will fit and will work in the new constitutional framework. I would say, again, one of the things, and most importantly, one of the things that this bill does explicitly is it takes out the good and substantial standard, which was at issue, at least in a different form, in the New York case. So we believe, and I say myself and the committee believe, that this addresses any issues that would be outstanding from Bruin and provides an objective standard that allows us to say, okay, here's when you can get a wear carry license, and here's where you can't.
Great, thank you.
Sid Nora. Okay. Hey, Mr. Chairman, thanks. It's always good to see you. Thanks for being here. I just have a couple questions around some of the and maybe some of the language changes that were talked. Chris, did you see the part about where it said under section B?
Yeah.
Where?
So that
The amendment is not on the table at the moment. Okay. So what about, so I like, that the work you've put into this, and I really appreciate it, Mr. Chairman. I'm just curious, what is your thought process on, so I have a concern that we're requiring or mandating certain training to be given as a part of the curriculum, de-escalation and those type of things. But we're giving there's no training guide by state police provided to these instructors to give a consistent across the board application of that standard that is being asked. So I think it would be appropriate, and I'm asking you, do you not feel the same, that it would be appropriate that we would have a provision in this that would require the state police to have some sort of curriculum crafted to address each of these specific items enumerated so that they're properly addressed? Because the worst thing we can do is go into this language and not have a standard application of the rules and a standard education of the standards that is being mandated in this bill, but these instructors are given no guidance. So the uniform applicability of the law is paramount. So if we're going to do this and we're requiring it, why aren't we requiring the training to be provided and given to them so that no matter where you go across the state, the training is the standard and it is all the same?
Well, the training would still be as standard as it is right now. The difference is, and again, I think it's sort of a moving target that I'm having to talk about here, because there's what we proposed in 824 and sent here, and then there's what Senate Bill 1 proposed that you sent across the street, and it's different. And in many ways, the training in Senate Bill 1 is more substantive. I think that what has worked for years and what I think will continue to work is when the state police provides a clear kind of syllabus or a curriculum for what needs to happen, and lays out what needs to be taught in those courses. We have not explicitly said that in the past, that we need to do X, Y, and Z, or we need them to do X, Y, and Z, but they have provided that broad framework anyway, and then instructors have taught from that anyway. The work on de-escalation and other issues, I would posit that some of the work that we did on police reform that dealt with issues related to de-escalation and to excessive use of force is transferable in some ways and that is work that's being done in the MPTSC. Having said that, I know that I believe that it's possible to perhaps have the Attorney General's office in consultation with the Maryland State Police put together that broad curriculum and find a way to make sure that the subjects that are covered, whether it would be under the legislation you have before you or under the expanded training that SB1 recommends, one way or the other, that instructors know what they have to be teaching and that it's taught uniformly across the state.
So I guess I hear what you're saying and I appreciate that. So would you be receptive to the idea of putting that language in there that would require that? Because we're talking about your self-defense, defense of another.
And I'm sorry to interrupt you. There are several vehicles that are out there right now. I know that's something that's certainly being considered in the House on SB1. If a similar amendment perhaps that was offered in 824, I don't know that would be something we would have a problem.
Okay.
I believe that asking the Attorney General to work with the MSP to put together that curriculum, I don't believe would be a bad idea.
Yeah, I agree. And I just want to make sure we're doing the best we can to ensure these law-abiding citizens that are taking these classes are provided that opportunity. So thank you, Mr. Chairman.
I actually think Senator Folden in your dialogue with him probably answered this, but let me just drill in a little bit. So do the state police currently provide training and courses for firearms instructors?
They provide, as I understand it, they provide a basic curriculum. I don't know that they train the trainers. And so but that has worked, and it has worked for the handgun, for the people who are doing the training. And it's worked for the state police for some time. So I'm not looking to necessarily upset the apple cart. Having said that, there are different concepts that are being proposed either in 824 or in Senate Bill 1 that could require a little bit more in-depth work. All I would say is if that work is going to be done, that we need to make sure that there's time for the state police to do it and then provide that information to the trainer.
And I probably just didn't follow your answer. So you're just so unclear. The state police currently create courses and provide training curriculum for firearm instructors. Is
Correct.
that okay?
That's my understanding, yes.
Okay. One of my concerns, I think the bill is, well drafted, but my concern is just in implementing it. One of my concerns is just
She
the
said it was
state,
well drafted. Sorry, go ahead.
the state police having enough money, manpower, and resources in the budget. The other question was just about connecting the prohibitions in the bill, adding about people that are on supervised probation under the alcohol driving sections on alcohol related offenses. So I guess it would be DUI, DWI, and then people even probation before judgment. So we were struggling a little bit. I think clearly the law or custom is that people that are habitually drunkards have a real problem with alcohol. I think there is some protection already that the state police have in law that they can prohibit someone from getting a permit. So, but we had a pretty lively and good debate about how many people get ensnared in getting a PBJ and trying to deal with the fact that many of them rehabilitate themselves and never have another incident and all that. So what was the thinking behind adding that restriction, particularly given how broad it is for PBJs to be given out in the state, which is, you know, not against the policy, just trying to think about the connection with this bill.
Well, first of all, in the section in this bill and in the section in this bill, it talks about being on supervised probation,
Right.
so not unsupervised probation. And it leads off with after being convicted of and for a violation and for a violation. So my presumption in going forward was this is for a conviction, that this was not necessarily for a PBJ.
Well, that, you know what,
So
I'm gonna just
that-
tell you, let me
that
just tell
was-
you that we've been told differently, so I think we've.
That's fine.
Cleared
I
that
mean,
up. That would be great.
you know, if it doesn't include PBJs, I understand that, and perhaps that would be more indicative of it being more serious and especially more important for those people not to be able to, for at least some period of time, possess a firearm. So again, the issue here, and the reason, by the way, that 21902B and C are pulled out is those that have penalties of 60 days. The 21902A and D carry penalties of a year. So the A and D would be covered by the first one, and the B and the C would be covered by the second. But I think that the argument here is during the time that they are on supervised probation, that's appropriate. That could be in district court, that could be any time between a minute and 3 years, or in circuit court up to 5 years. But generally speaking, they don't, for those kind of cases, they wouldn't exceed the 3 years when they couldn't apply for a wear carry permit and not be able to possess a regulated
Then
firearm.
we'll get a clarification, because we just had a different understanding of how this.
The idea was that these were all convictions that they didn't expect the PBJ to apply.
All right, thank you. Thank you, Mr. Chairman.
Thank you. Welcome, Mr. Chair. Two quick questions, hopefully. One, I understand the increase of fees and the rationale for the initial application as well as the renewal, but also the course itself costs money as well. And I was wondering if there was any contemplation about how much the increase of training might result in an increase of fees for the courses.
We did not discuss that in the Judiciary Committee. What I'll point out is the last time the fee was increased was in 1992. It was by William Donald Schaefer, and he proposed raising it from $50 to $235 for an initial application. So it ended up back at $75. I think given the cost to the licensing division, again, what we sought to do was keep the increase in fees to be lower, and I think significantly lower than what the actual cost to do licensing was. With regard to the cost of the training, yes, there are costs to purchase the firearm. There are costs to go through this process. I'm not gonna I don't want to say that they're de minimis. I don't want to say that they're irrelevant. But what we were seeking to do was to make sure that the fees that we were charging were better reflective of what that the fees we were charging were better reflective of the cost of the licensing division. And again, we did not address issues related to how much the training costs, because they're done by people outside of state government, and we don't set those fees anyway. So
I understand. I guess I was thinking though that it already is, this is a wide expansion of the training, which I think is all good and probably beneficial. My thought was just, I think it's a couple $100. Could this level of training, did they even weigh in and say like, well, if we have to do all of this, we're gonna have to charge like $1,000 for the course or something like that? I was just curious about that, but
we didn't hear anything like that.
the other question I had, following up on what Senator Mary Delaney James was asking, under this bill, if someone's already licensed and then they get one of these offenses and are placed on supervised probation, would they then have to surrender their firearm until they are finished with the probation?
Until they were finished with the probation, yes, they would have to do that. And that's consistent with what we have in current law with regard to whether people have been convicted of disqualifying crimes. or other crimes where they received a term of imprisonment of more than 2 years or anything else. We would require them to turn in their guns. We require people to turn in their guns if there's an active protective order against them. So it's consistent with that.
Oh, I completely understand. I just.
Yeah, no, my tone wasn't totally perfect there. I get that. I'm just saying it's
I was
consistent with what we do in the law.
a little concerned about that.
I understand.
But because it could cause someone to lose employment, like honestly, if someone got a PBJ for a DUI, which we did think was included, because you can get a supervised probation with a PBJ. And they had a security job where they had a licensed firearm and then they had to give it up, then it could have a ripple effect where they lose everything. And for it, which they probably shouldn't lose everything for the PBJ. DUI, supervised probation.
Well, and that's why I don't think it was in the committee's, the committee's idea was not necessarily to include the PBJs, it's to include convictions and not the PBJ.
One last question, if I may. The
You
other,
said 2 questions.
oh, I know, but I just.
So nice. I would,
I-
so nice. This is so, look.
Clarity, and sure, we could look it up, or maybe this is even for council. Senator James did ask about the reason for the connection, the correlation between the offenses listed. And one question that we did discuss when we talked about the bill was why not just any supervised probation, or what are the other offenses that someone could be subject to a year that would be covered by this outside of the DUI offenses?
Well, I think that again, the situation again is that we're looking only at supervised probation, only at convictions. So the lesser violations could be something like a misdemeanor theft or a shoplifting or something along those lines could fall underneath a year, because its maximum penalty is, I think, 90 days. There are lower level crimes that we didn't think rose to this. What the reason for this was to say that 1 year is a good line to say, at least during that time when you're on probation, during that period of time, or for that crime, then you would lose the ability to possess and to be able to get a wear carry permit. And then in particular, we chose, and to build on what Senator James said with regard to the DUIs, I mean, it is an extension of the habitual drunkard language, which is the most interesting turn of phrase in this part of the law. But having said that, the idea there and with the domestic violence language is there are issues there where those are clearly very challenging. Those are very challenging to public safety, in particular, DUIs and for somebody who has violated a protective order, those in my mind are red flags. And that's why during the time that they're on probation, we thought that was appropriate.
Thank you very much.
Thank you, Senator.
No, thank you. Thank you, Chairman. It's funny. We had the conversation about the habitual drunkard and the nexus between that in the back room there. So thank you for offering your thoughts on that. All right. We just have a few more lines of questions because we do have voting and we have a hard out at 4 o'clock today and the chairman needs to get back to his committee. So Senator Folden, you're up.
Thank you,
Second
Mr.
bite,
Chairman.
Senator Folden.
Second bite. I know you got to go. I'm sorry, Mr. Chairman. So I just have a couple, as I'm looking through here and I'm trying to listen to you and pay attention to this magnificently crafted bill, I'm being told
Look at this.
by Holly. So is this a standard? So for a traffic violation, adding in 21,902 was seen as something that should be concerned with the carrying of a firearm?
I think it is. I think that if you've been convicted, in this case, convicted, not a PBJ, if you've been convicted of driving while impaired or driving under the influence, that during the time that you are on probation for that should be a disqualifier.
Okay. And
again,
that's a lifetime disqualifier?
No, it's not. It's only during the time that you're on supervised probation.
Okay.
And so if
But-
the judge makes a judgment that says, we think that the judge says, I think you should be on unsupervised probation, it wouldn't trigger this.
So if the person goes out, is drinking, they're not carrying their firearm, they're not in the bar with it, they have it at home. If they get arrested for that offense for driving, they would have to surrender their weapons.
I think you could also make the argument that if you had somebody who committed a crime and got 2 years in jail and committed a first-degree assault and they did it with well, maybe first degree assault's not perfect because I would be thinking of something perhaps other than a gun, but some other crime where they got 2 years in jail and they did it without their gun and everything else, they're already prohibited. under
Yeah,
the law.
but those
So
are
this is a
crimes,
consistent-
those are crime, I apologize. Those are
No, you're
crimes
fine.
that would be with malice aforethought that have a malicious intent. Whereas DWI is someone that may be presumed that they were not impaired to a degree. There's no intent of malice. Now, is there consequences to it? Sure. Should they have made a better decision? Sure. Should it be a disqualifier and make them surrender their currently possessed firearms, making them a prohibited person? I have a problem with that because there is no intersect between the two.
There's a large number of crimes that don't need a demonstration of malice, including driving under the influence, but also including second degree assault, including a wide range of other crimes that don't require malice to be involved with it. And look, I get your broader point, and I'm seizing on the word malice because that really doesn't have anything. It's what you said.
That's what I said.
And it's not what your bigger argument here is that, you know, this doesn't have a nexus to the gun
Correct.
directly, but we're making a public policy decision here, as we have
And-
with the habitual drunkard language that's already there, and extending it and saying, if you're convicted, so almost certainly the second time for a DUI, that we think that it's appropriate for you to not be able to possess a regulated firearm for a period of time, for for your supervised probation.
Well, and I'm glad to hear you talk about that. We're making, this language that's required. But so I also noticed, we've discussed this before, there's nothing in here that would afford, it only talks about state, county, or municipal retired law enforcement. It doesn't have anything for federal agents or those that are in the,
That's existing law. I didn't touch anything with regard to the exceptions that are in 5133 or in the where carry,
Okay.
in the where carry exceptions
okay.
that
so this
exist.
is-
I went on to the requirements. I didn't go into the exceptions.
Okay.
I believe I did.
All right, so you believe that's in the
That's right.
exceptions, right?
Right. So that
Okay.
was one of the exceptions. I think you're talking about the where carry section. So I didn't touch,
I'm
I didn't
just
touch
talk-
any of that. So the
Yeah.
bill doesn't touch it.
Well, I'm just saying, like, there's federal officers that are contacting my office saying that they're not covered in this and they would like to have that
So
pass along them once they retire.
I can have counsel clear that up, but that's a drafting feature. It's still in the statute. And
Right.
so it's like 16 pages.
Okay,
It's very long. So
Right.
just as a drafting feature,
All
it's
right.
not contained in the bill, but it's still in existing law.
thank you,
Right.
Mr. Chairman.
Right.
And then the other point that I wanted to make is we have in here 8 hours of instruction for a renewal application. Is that for like updating, like training standards or things that might have been changed? Because right now they update every 3 years?
So I'm I think I'm in a little bit of two worlds here where there's a bill that's in front of you and there's a bill that I think that is floating around. And the bill that I think that where amendments had been proposed with regard to were the ones that you included in Senate Bill 1, which included that 16 and that 8 hours of training. So that is reflective of what you passed in Senate Bill 1.
So we have another bill that's not a direct cross file, but has some of the same language.
Well, you sent over Senate Bill 1 with that training language in it.
Mhm.
And so I think I've got that right. Wait, I'm making sure I've got that right. Right, so this, as I believe there is a proposed amendment before this committee, the training language that was sent to the House in Senate Bill 1 has found its way into an amended version of House Bill 824 that is before you right now.
Okay, so this is why.
Which is why I'm
Yeah.
doing a bill hearing, but there are amendments that are out
Yeah.
there that.
Mr.
so
Chairman, I get it, and
Yeah.
I appreciate you. This is why I felt it's really important to have this discussion
Sure,
in the public eye, because we
I'm
don't,
happy to visit JPR. It's
I
fantastic.
appreciate that. So as far as the curriculum though, we're going back to the curriculum, and I think there was I would really like to get this on the record, but there is no curriculum that is required, that is provided by the state police to these firearms instructors. There is none. I think the answer was given that there is none.
But they provide I think that what they provide is a basic framework that could be described as a curriculum. And then they build off of that. Look, to be clear again, and I I feel like there is actually agreement here. So I do not have a problem if the Attorney General, consulting with the Maryland State Police and perhaps even the Department of Health, but certainly the Attorney General and the State Police put together a curriculum that would address the training issues that are necessary that were sent over in Senate Bill 1 or that could live in House Bill 824.
And I think we can agree that the importance of it is because we're talking about things regarding the law concerning of armed trespass. That's not a firearms instructor from the NRA's forte to be speaking about case law and the importance of knowing that if you're trespassing and the criminal consequences and loss of your privilege that could happen. And then the other part about conflict de-escalation and resolution, anger management. These, you make a valid point about, do we get the mental health side of the house involved in this? And I think that's a great point that there is, if we're going to mandate these, then we should have some direction and we're putting ourselves in an azimuth here. And that direction needs to be fully vetted and inclusive of all these different things to include this suicide prevention. But if we're just telling them, hey, we need you to touch on suicide prevention, which is kind of how it's written now. These are the things you need to touch on. So if they say, hey, if you don't, we're worried about suicides by firearms, so secure your firearms. That literally by the standard now could be the one that covers it.
So as I mentioned, the Attorney General touches every single department of state government. And the reason to engage the Attorney General in this work would be because they have attorney generals, assistant attorney generals in every single agency of state government, and they could draw from their expertise to put something together with MSP and others. And as I mentioned, I think we agree, Senator.
Yeah, I agree. And I just
we got to move this on, but
I violently agree with you, Senator.
I just want to hear you say it
You got it.
one more time. Mr. Chairman.
you are speaking his language, Mr. Chairman. Yeah.
Thank you, Mr. Chairman. I appreciate your candor, my
fine.
friend. Thank you, sir.
For what it's worth, the handgun instructors we've talked to, the curriculum is not overly prescriptive. It's kind of broad based. And so I think what you're proposing here marries the two. And I think it's a great idea. And so I appreciate it. Thank you very much, Mr. Chairman, for taking the time to be here. With that'll conclude the testimony for the proponents of the bill. I think we have 2 people in the queue who are going to testify online, but please feel free to leave JPR. I know you love it here, but I know you have work to do.
Thank you.
Good to see you. Hey, thanks a lot. All right. Broad basin. So I think what you're proposing, Mark Hennick, if you are, if you have your stream, or John Jocelyn, if you're streaming on YouTube, include the, you can just the proponents of the bill, I think YouTube stream or close the browser. All right, Mr. Jocelyn, you're up. Welcome.
Thank you, Mr. Chairman. John Jocelyn speaking for 2A Maryland. I'll focus on the training aspect. The Maryland State Police, when Firearm Safety Act of 2013 was first signed into law, they provided a suggested training curriculum for the handgun qualification license. They provided nothing for the carry permits, which are the focus of this particular piece of legislation. They provided us with a score sheet, a certification form, and a course of fire for both the handgun qualification license and the carry permit. As far as anything else beyond the handgun qualification license on Maryland law, case law, certainly nothing on federal law, none of this was provided. This was all left up to the instructors, and each instructor is doing the best job they possibly can. However, there is no continuity across the state in the way these courses are taught or in the content of the courses. That is one of the main issues that we had with the training component. We remain vehemently opposed to merely throwing this responsibility on the instructors and giving them no support. I did put in a PIA after 824 passed on the floor. The Maryland State Police responded. I've emailed you all of that data. You will see from the documentation they sent you, they have nothing on the carry permits that addresses the components of House Bill 824 as is currently crafted. We strongly urge you to reconsider this piece of legislation. It will do more harm than good, and it will make it more difficult to get insurance when we are trying to teach something we have no qualifications for. Very possibly insurance underwriters won't even touch us as an insured person because they're worried about liability. The state needs to do better for us. They shouldn't just throw us to the wind and give us a responsibility with no support. We remain opposed to House Bill 824.
Excellent. Thank you very much, Mr. Jocelyn. Mr. Penick, you are up next. Welcome. We'll have you unmute yourself and then we'll be ready to go. All right, you're up.
Thank you, Mr. Chairman. Mark Penick, Maryland Shell Issue President. We remain opposed to 824 for the reasons we submitted in written testimony over in the House. And I wanted to call in particular attention, I mean, that written testimony, it should be in your packet that came over from the House, but I wanted to call particular attention to the doubling of fees associated with the licensing permit system. And I heard with interest the chairman Clippinger's remarks that it was based upon the total cost of the licensing division. Now it's unconstitutional, and as the chairman referred, to have the licensing division be a profit center. But the two cases that are on point here is Cox versus New Hampshire and Murdoch versus Pennsylvania, and they are addressed with the cost of providing the license itself, not all the costs associated with the bureaucracy of maintaining the licensing division, which does a whole lot of other things other than just issue carry permits. So I want to draw your attention to the fiscal policy note that went over, that accompanied the House version of 824 when it was passed. And it showed that the revenue gained by the doubling of fees is in excess by double of what it costs the licensing division to administer these licensing provisions. That's a profit. Now, whether or not it covers the total cost of the licensing division is irrelevant, because of the Murdoch and Cox, those costs are irrelevant. So what it costs the licensing division to administer this particular program is what matters, and the licensing division will make an immense profit on this. So for example, in just fiscal year 2024, the revenue is going to be 8.7 million. The expenditure is going to be 4.3 million. That's unconstitutional. It'll be count one in the complaint. So I urge the committee not to adopt this increased licensing fees. Thank you.
That's it. Thank you very much, Mr. Penick. Question from Senator Folden. And then Senator West.
Hey, Mark. Hey, John. Thanks for coming out and testifying. I appreciate it. I just wanted to touch base on, you've heard the testimony that there seems to be a little more receptiveness to providing some of the standardization of this training curriculum, which would help out immensely. I know we just got these copies within the past 12 hours of the updated version. And now here we are at least we're having a bill hearing, I suppose. Is there any other areas of concern that you all have that we should be looking to pay attention to on this that should be of concern? Or are we just really focused at this point looking at that specific area of the training curriculum standards?
I'll jump in on that, and I'm sure John has comments as well. The disqualifications associated with this bill, including one being on probation for a crime of punishable by up to 1 year if it's on supervised probation, I think probably is likely to be unconstitutional. That's being litigated now in the Range versus United States case, the Third Circuit in Bank. It's being litigated in other provisions in district courts all over the country. I would call your attention to the Justice Barrett's, then Judge Barrett's the dissent in Cantor case out of the Seventh Circuit, on which the test for disqualifying an individual for the Second Amendment rights was laid out. And I think that's ultimately will be adopted by the Supreme Court and by the Third Circuit. So you're running a risk there. I would say the subject matters that are taught by instructors. I'm an instructor. I've taught this course. I'm uniquely able to teach a lot of this because I'm not only trained in firearms, but I'm a member of the Maryland Bar and DC Bar. But I got to tell you, I don't have any instruction experience at all, and suicide or some of the other matters in which this bill will now require me to teach. So I would welcome guidance from the state police on a curriculum, at least for those matters. I can teach the case law, and most instructors can teach the case law too, because there's not that many cases involved. But there are no statutes on self-defense, for example. There are no statutes in Maryland at all on these subject matters. So it's all case law. So you really need to be at least conversant with some major case law that's in Maryland law.
Yeah, so your concern comes up then in what I guess I was offering earlier, which was we have a nonviolent crime, which is in the transportation article that now is going to become potentially a disqualifier. Is that what you're
Yes,
referencing?
it's exactly right. And that I don't think is going to be constitutional.
Okay, I appreciate it. John, did you have anything?
I agree with everything that Mark has said. And I would go on to address 5-310. There's a small change there that removes the flexibility the Secretary of the Maryland State Police has with regard to revoking a permit. I think that we should have faith in our Secretary of our Maryland State Police and give him some discretion on whether or not to revoke a permit. There's always gray areas involved, and I don't think we should make a hard and fast rule. Revoking based upon that, while a person of means may be able to appeal it with an attorney, a person of limited means would not be able to do so. I think that we really have to put more faith in the law enforcement agencies, and particularly in the Secretary of the Maryland State Police, to use good judgment in determining whether or not to revoke a permit.
Okay, great. And then I did want to touch on one last point before I close out here, guys. So thank you all for rushing on here. I know this was a very late notice that you guys got on here, and I really appreciate your time. So, Mark, are you referencing the fee, I guess, going up for the licensing fee would be going up? And what was, I don't know the number off the top of my head. I'm looking at all these different fines of 250, 75 to 150. So do you see this as a more prohibitive for some of our more potentially underserved communities, and being a prohibitor and being able to get, one, you got to get the license, then you got to pay for the class, which is a few $100s. So it almost seems to be making it a little more prohibitive in doing this.
Oh, it absolutely does. So let's just talk about the cost for a moment. So you have the existing licensing fee for initial permit of $75. Then you tack onto that the cost associated with the live scan fingerprints. That's about $70 too. And that's all out of the individual's pocket to a private live scan vendor. Then you have to take the course. The average cost of the course is $400, and that's a big class if you can find it. And then you're going to have to spend the costs associated with traveling to the range and doing 16 hours of training, including firing lots of rounds. And when I teach the course, you fire hundreds of rounds. So those are very substantial costs. And if you start doubling the fees beyond what we already have, you're going to price out of basically the people who may need it the most, the people who live in the urban areas that their lives are more at risk than say yours or mine. So this is already a very high cost. And you compare this to other states like Pennsylvania, it's $20 to get.
Gotcha. It's pretty significant difference,
Yeah.
huh? Okay. And then, Mr. Chairman, I just want to point out, and not to be, I do appreciate you opening the forum up and allowing, you know, our two witnesses in opposition come forward. But I take exception with something that's such an important issue, having such a late notice that we couldn't provide for witnesses. And I mean, it's just such a very important issue. There's people that are protecting their rights. And I think that we should always, and I know we're trying to here, but I still don't feel comfortable that we should always be engaging the community trust and public trust by operating under the guise of, in daylight, in the light of day. And this one came up quick. It was a late notice. We were made aware of this was going to be a hearing about, I don't know, 2 hours ago. So I just would ask and implore in the future that we provide for something that's such an important issue.
Yeah, as you know, we're on a truncated schedule, and we are in the midst of a hearing, but also every touchstone, every element of this bill has been heard albeit in another bill, or two other bills, or three other bills. So every element of this bill has been heard in a formal hearing and thoroughly vetted. Obviously, we make amendments on the fly, and not every idea and every amendment has its own hearing. So we are being overly inclusive in this, especially given the late hour of session, but just for the record, every element of this bill has had a formal hearing, thoroughly vetted and subject to public inspection and debate. With that, we'll go up with Senator James and then Senator West.
Thank you, Mr. Chairman, and thank you to the two gentlemen who just testified. I know we're on a very tight time frame here. So gentlemen, you gave a couple of cases, Cox and Murdoch's, you mentioned Judge Barrett. So, and I just looked through some of the testimony. I know you probably didn't provide this already. So could you send it over? I guess I want to see it. I guess everybody would want to see it, right? So if you could send over the citations for the cases that you just and anything else that you have regarding your testimony today. And if you could do it quickly too, because I probably have to look at it this afternoon, if that's
So,
possible.
Senator Jay, I'd be delighted to. I think I sent my 824 testimony to staff counsel some time ago. He may have it available right now for you by email, and he may be able to distribute to you right now. But I'd be delighted to send it right now.
All right. Yeah, I have some testimony, but as I was going through it, I didn't see those cases. So if I missed it, I'm not trying to make extra work for you, but just given how rushed we are, getting that information one more time would probably be really helpful to me.
I'll do it right now.
Thank you, gentlemen.
Thank you, Mr. Chair. I'm going to be very brief because I know we have a hard stop in just a couple of minutes. Mr. Pennick, in your testimony, which I do have a copy of, you weigh in about the prohibition of giving permits to people who are between the ages of 18 and 21. And you cite a couple of cases which themselves rely on the Bruin decision. Is there any update there, or is this the current state of the law?
It's actually, there are updates there. A federal district court in Minnesota, appointee of President Biden, no less, has just struck down the limitation imposed by Minnesota law on carry permits to persons between the under 21. And the case name is Worth versus Harrington. And that was decided last week. And they relied heavily in that decision on the analysis of and the historical approach by the Fourth Circuit in the Hirschfield case, which I know you're familiar with. I touched upon that in my testimony on SB1. That's a Fourth Circuit decision that was vacated as moot when the person's aged out, but has been since cited repeatedly. There's a Fifth Circuit District Court decision called McGraw versus Texas, which the Texas has acquiesced in, that had the same ruling about permits to 18 to 20-year-olds. So that's an area of developing law, and thus far, those have fallen. There will be an Eighth Circuit appeal in the Minnesota case, so I'm confident of that. But the analysis in the Worth case is actually quite compelling.
Great. Thank you very much. It sounds like, if anything, the law has moved further in the direction of substantiating your constitutional concern about a prohibition permits being granted to people between 18 and 21.
I expect this provision will be challenged if it's enacted into law.
Thank you very much.
All right, seeing no further questions from the committee, thank you both very much.
Thank you.
And that'll end the hearing and the testimony for House Bill 824, and we'll gavel out. We are going to conclude our work for the day. Today is for those who observe, is the first day of Passover at sundown. So it's 4 o'clock. I want to make sure everyone has an opportunity at home to their families to observe Passover. And so we'll reconvene tomorrow at 9 a.m. for a voting session.